Now, in his first official reaction to the Supreme Court pronouncement on the political crisis in Rivers State, Governor Sim Fubara has bowed in obedience to the court. He's directed all local government chairmen in the state to step aside and to hand over to the heads of the local government administrations in the various council secretariats. The Supreme Court had earlier cancelled the election that brought in the local government chairman. Governor Fubara, though, was clear that he disagreed with the judgment of the court, and he did not address the other aspects of the Supreme Court's judgment, which ordered Nigeria's Accountant General to cease sending funds to Rivers State until the governor presents a budget to what the court called the legitimate House of Assembly. The court also declared Martins Amewule, who supports Minister Wike, as the legitimate Speaker of the State Assembly. There is, of course, another case that's pending before the Federal High Court in Port Harcourt, brought by Victor Oko Jumbo and two others against Mr. Amewule and 24 other Rivers State lawmakers on their defection from the PDP to the APC. What a right royal legal mess. So how does all this affect the standing of the judiciary? Well, to help us untangle some of the knots, I'm joined now from our studios in Lagos by the president of the Nigerian Bar Association and senior advocate of Nigeria, Afam Osigwe. Mr. Osigwe, thank you very much indeed for joining us. Really nice to have you on the program. I know you didn't really want to get into the issues around Rivers State, which are largely political, but I mean, there are legal issues which we would really benefit from your assessments, no matter how peripheral they are, because you are, after all, the president of the Nigerian Bar Association. So, I mean, my first question is, how do you assess that Supreme Court judgment on the crisis in Rivers State? Is it pretty straightforward to you from a legal perspective, or does that judgment further complicate matters?
Thank you so very much for inviting me to be on this program. I will comment with respect to the issue in Rivers State to the extent that the judgment is a judgment of the Supreme Court, and that makes it a final judgment of the courts with respect to the issues resolved by the court. And it is thereby binding on all the parties, and the parties are expected to obey the judgment of the court. It doesn't matter whether a party likes the judgment, whether a party feels that the judgment has favored him or not. I listened to the statement by the Rivers State governor, and it reminded me of the statement by Al Gore in 2000, when the Supreme Court, by a decision of the Supreme Court of America, victory was effectively handed over to Judge W. Bush. While he expressed his disagreement with the governor, with the judgment of the Supreme Court, he expressed a willingness to abide by the same. And I think that's what is expected of parties to a suit. And I think that's what the governor of Rivers State has done. Whether it resolves the lingering political issues in Rivers State is a matter for the politicians and the political parties to x-ray and look into. But I can only express a wish as a Nigerian who prays that this judgment will to a large extent help to douse the tension in Rivers State, and that the political players will also see this as an avenue to sit down, if they have before now found it difficult to talk, to find ways to reduce the political tension in Rivers State so that governance in Rivers State will be for the benefit of the people. But all in all, is a final judgment of the court, and parties are bound to obey it, and we cannot afford to pick and choose what judgment to obey or use foul language on the Supreme Court, where the decision does not favor us. It is the decision of the Supreme Court must be obeyed by all parties to it, and that is what is expected of parties to this judgment.
Indeed, and thank you very much indeed for that very unambiguous opening sort of statement there. But I mean, what complicates this is that it is both a legal and a political matter, because some legal analysts have suggested that it should not have been taken to the courts in the first place, because the courts are now caught in a twist themselves and are deepening the complications by delivering many judgments, some of which end up contradicting each other. I mean, what's your take on that?
Well, I am not sure my attention has been drawn to any conflicting judgments of the court. And also, in answering your question, I warned myself that some aspects of this matter are still pending in court, and it will be prejudicial for one to make comment on them. But with respect to the issue that the courts have unambiguously resolved, parties are expected to abide by them. Well, it is for, there are different shades of opinion as to whether the matters ought to have gone to court. Well, it is safer that matters are taken to the court for amicable resolution than the parties take the laws into their own hands. And the courts are there to do just that, to adjudicate in dispute between parties, whether they be individuals or political parties or states or local governments or the state versus state or state versus the federal government. That's what the courts are there to. If the politicians are unable to resolve their disputes or their conflicts, then the court, and then in the jurisdiction of the court is invoked, then the court can only do that by stepping into the matter by deciding it and also handing down the decision that parties are expected to abide by. I'm not a politician, so I may not be able to comment on why they found it difficult to resolve their disputes. But the court has spoken, and the people are expected to respect the decision of the court. Nothing more, nothing less can make for peace in Rivers. Also, the parties can shake their swords and find solution that works for them outside of the strict legal interpretation of the judgment of the court. And I must go further to state that I'm not sure that the judgment of the court is available. All people have been commenting on excerpts of that judgment as have been available on social media. And I would not be drawn into discussing a judgment I have neither seen nor read. But all we ask for is that there be peace in Rivers, that parties abide by the outcome of this judgment and respect the sanctity of the decisions of that court, because it is final. And the finality of it is to decide the rights and obligations of the parties. And people are expected to do that which makes for peace in Rivers. And people are also advised to eschew personal interest and work for the greater good of the people of Rivers State. That's the much I can say at this point.
I do know, of course, that part of your remit as president of the Nigerian Bar Association and your own personal commitment is that of reform. You want to see the judiciary become much better. You want to see the whole legal environment improve dramatically. And I wonder if judges becoming more exposed to these types of political cases, the more they become exposed to them, exposes the judges themselves to potential manipulation by the politicians, and whether that is an area that you and the NBA are quite keen to address and potentially see reformed, if it is the case.
Well, different issues that go before the court raise the suspicion that they may be somewhat influenced by them or manipulated. But until there is evidence, until evidence is offered as to actual manipulation, that remains within the realm of speculation. But we would want to see our courts continually give justice that resolve disputes, reduce the tension in the polity, and also give justice to the parties, not just judgment. That is the kind of reform we want. Give efficient and effective justice delivery system that ensures that people don't spend a very long time in the court, so that matters are given utmost attention. And that the current situation where we have political matters being given priority in our courts to the detriment of commercial cases, the criminal cases, and rights abuse cases is brought to the barest minimum, so that the political disputes do not clog our courts. That is the kind of reform we have. Whatever the nature of the case, there will always be the suspicion, and it is normal with human nature. But we would also want, where there are proven cases or grounds to believe that there have been manipulation, for petitions to be written to the NJC and for NJC to take appropriate action. We cannot speculate. We cannot deal with the realm of suspicion to suggest that courts will not do their work. That is what they are there for. Even in matrimonial courts, there will always be suspicion that people may want to manipulate the court for one reason or the other. And we should not, because of that, suggest that because the court is saddled with determining many political cases, that it thereby makes the court susceptible to manipulation. No, I don't subscribe to that view.
And of course, you talked there about the importance of time spent in court being reduced so that people can, have speedy justice dispensed, and because that's obviously an important thing, and that's an important area of reform. I think a lot of people would agree with you, but I'm wondering, given that, as you look at this broad realm of reform that you're talking about, is it time perhaps for the judiciary itself to try and tighten the rules and perhaps regulate when and in what circumstances political cases can be brought to court? Or is that not within their purview?
Now, it is not within the purview of the judiciary to do that. Now, if you look at the provisions of the law that give priority to pre-election and election cases, they are either to be found in the Constitution or in the Electoral Act. And the duty of the judiciary in that regard, or their power, only extends to making rules of procedure as to how they approach the courts. But the fact of the rights of aggrieved parties to approach the court is either constitutional or statutory. So it is not something for the court. All that the court can do is to apply the rules to ensure that those who have invoked their rights, constitutional rights or statutory rights to approach the court, that they get even-handed justice. It's not for the court to be a gatekeeper, keeping out those who can come and those who cannot come. But then again, the courts and the legal profession can drive a reform process, for example, that seeks to limit the quantity of the types of cases that come to the court. Personally, I am of the view that pre-election matters should not have any place in our courts, that the political parties should be able to choose their candidates, and those that are aggrieved should resort to internal dispute resolution mechanism within the political parties, that the court should not be dragged into resolving these matters, that they shouldn't be justiciable, because they are among the cases that clog the courts, unduly delay cases, unduly affect the progress of other cases within the court, because during the periods that the Federal High Court hears these cases, they have to largely suspend the hearing of most other cases, and it puts a lot of pressure and burden on the judges. So the judiciary, yes, could suggest reforms, especially at this time that the National Assembly is embarking on a constitutional amendment process, to suggest matters that may not be covered, and it goes beyond politics. I mean, at this age and time, I don't see why customary law issues, landlord and tenant issues, just every matter should go all the way to the Supreme Court. We should be able to determine the nature of cases that should go on appeals to our courts and the cases that should not go beyond the appellate courts, so that we reduce the burden on our courts and also reduce the time wasted and the money wasted in ensuring that every case goes all the way to the Supreme Court. There's no way the justice of the Supreme Court can handle this large volume of cases. And that may explain why, in some cases, it may take a minimum of 10, 12 years for appeals to be heard at the Supreme Court. Because for every time the court is poised to hear these cases, political cases come disrupt them, and then the avalanche of these cases make it difficult for matters to be determined within a short period of time. And maybe we should look at the American system that allows the court to determine cases that could be heard within a judicial year, and so that cases that are not accepted for appeal are deemed automatically dismissed. We can't have a situation where cases take 12 to 15 years to be determined, and where men and women who are largely in their late 60s or heading towards 70s are saddled with the responsibility of sifting through these large volumes of documents and making pronouncements. Matters that should go to our Supreme Court should be matters that raise constitutional issues. Matters that require that the Supreme Court should establish rules and make for certainty, especially where there have been conflicting decisions of the appellate court. But every case should not find their way to the Supreme Court. It's impossible for us to cope, and we'll always complain about delivery in the administrative and justice delivery system because of some of these issues. Maybe we should have that hard conversation at this time. Maybe the Judiciary and the NBA and other concerned bodies should have a role to play to bring about these reforms.
That's a very interesting analysis from you, very illuminating. But at the risk of making you repeat yourself, because I mean, I quite enjoyed listening to your assessment there. I wonder whether you would delve deeper into that assessment of the capacity of the Supreme Court in particular and courts in general to deal effectively with the cases before them. Because, I mean, it raises a fundamental question, doesn't it, of the issue of justice and how quickly people can be assured of that.
So we have to find a balance here. We cannot afford to rush the cases through the courts, because some people say that justice rushed is justice crushed. And then also justice delayed is justice denied. So we need to find a balance here. I think the men and women who man our various courts, the various judicial officers, are sufficiently equipped. But the circumstances under which they work sometimes make it difficult for them. Now, the world is advancing. Technology is playing a great role in businesses and in the social communications amongst people. but the rate at which their courts are embracing them and deploying them for use is very slow. It could be much better. It could help the courts in dispensing justice, in hearing matters and not making people travel all the way to different courts for their hearing. And also the large volume of cases makes it difficult for you to really swear that every case gets the required attention it gets. If a justice of Supreme Court has to write, for example, 75 judgments in a year, that puts a lot of pressure on the person. And one may safely surmise that it may have a bearing on the quality of judgment delivered by this court. So you need to look at the quantity of cases that go for adjudication before them, and some of which they must deliver judgment within a specific period. For example, electoral matters, and I go back to them again. They are required to give judgment within 60 days of the judgment, or is it the filing of the notice of appeal? How do you expect them to cope? And sometimes lawyers' insistence that their matters be heard, even though they have raised no real issue, even though the authorities that have actually settled the issue they are presented. And sometimes too, lawyers do this because sometimes they need them for application for the rank of senior advocate of Nigeria. And you talk about a system where the courts are overworked, where everything is flogged into the Supreme Court and dumped on the court to decide. And there are politicians too, we insist on filing appeals, even though they know it has no merit. And counsel, of course, lawyers. And so that it will say that if you don't go on appeal or challenge your laws, they will say that you have collected money. And then they want the court to determine and say, oh, if not that they took a bribe, I won the election, the court robbed me of victory. So people even have ulterior motives sometimes in filing an appeal. And there are people who have genuine reasons for going on appeal. I'm not just saying that all cases have no merit, but I'm just talking about that all these aggregate into the large volume of cases, the large quantity of cases to be decided by these judges. And there are human beings like me and you who hardly have time for themselves too. And they're supposed to work under very difficult conditions to ensure that they deliver justice within time. And this no doubt may affect the quality of their judgments or the quality of their decisions. Not that they are not sufficiently equipped, but sometimes the work may be overwhelming and too much for them to handle. And that takes me back to my suggested reforms on how we can free up the courts so that they have adequate time to consider the cases and give judgments that set precedent so that people will not be in doubt as to what the law states. So that where there are contradictions or confusion about what the law really is, they will be able to straighten them out and lay down decisions that will guide us in our actions and giving advice to our clients.
And of course, having done all that hard work that you're talking about that potentially could overwhelm some of these judges, you have the nettlesome issue of the obeying or disobeying of court orders. I mean, I wonder what your thoughts are on that and whether it's improved under the current administration or whether it's pretty much the same as it has always been under previous governments.
Now, let me say this. A number of times, there are deliberate disobedience of court orders by government in manners that spawn or hold more like a contemptible of the court. Then there are the ones that do not appear to be in contempt, to have any disrespect for the court, but also undermine the administration of justice. Many judgments are awarded in civil matters against government or their agencies, whether local government, state or federal government, are not being enforced because of the provision of Section 84 of the Judicial and Civil Processes Act, which requires that the Attorney General must give consent. Now, because of this, many people have judgments but cannot reap the fruit of their judgment. So it is not a deliberate or willful refusal of the government. And I wouldn't want to compare whether this government or that government. Successive governments have relied on these provisions of the law to refuse to obey court judgment. Like I said a few days ago, I am told that there's a recent judgment of the court where Justice Ogunwumiju held that that provision of the law is unconstitutional. But it would appear that there was no unanimity by the other justices of the court who sat on that panel. But I think it is time we had this conversation and I tell ourselves that such a provision which makes it difficult to enforce judgments against the state and which impliedly show refusal to obey judgments or orders made by a court should be declared unconstitutional and removed as a clog in the way of enforcing judgments against the state. It does not operate against private individuals or companies. It's only the state that uses it to its advantage to prevent people from enforcing judgments against it. And yet, most of these cases require that people reap the benefits of their judgments because many people wait to enforce the judgments and die without getting this done. And it should worry all of us because it affects the confidence people have in their court. Many people are no longer willing to litigate some matters in the court because they will tell you that you pay legal fees, you get a judgment you cannot enforce. Of what use is it to go to court? And it affects the perception, the positive perception people ought to have about the judiciary. When people feel that the court could give you judgment that is meaningless, is worthless in your hands, which the state will prevent you from enforcing, or why the police will not even approve for policemen to accompany you to go for enforcement of judgment. And maybe we should also look at that system and ask ourselves, maybe the court should have their own armed enforcement unit that will not be dependent on the police, so that the police cannot, by willfully refusing to approve policemen to accompany the bailiffs or the enforcement officials to go on enforcement, undermine the enforcement of judgments or prevent people from enforcing judgments against the state. So the enforcement of judgment could either be willful, a government expressing a desire not to obey judgment, and then could also be systemic, where the law is relied on to prevent the enforcement of judgments. Whichever one is the case should worry all of us. I wouldn't want to compare whether it is worse now or better, but most people have judgments they cannot enforce. And some have had it across many administrations, both at the federal and state levels, and they can't enforce them. And that undermines the integrity of the court, undermines the confidence people have in the ability of our courts to resolve disputes between people and ensure that justice is done to people who are wronged.
And those are very important remarks that you've made, and I certainly hope that you're taking them beyond just this forum to places where decisions can actually be taken and considerations of such matters can be made. Afam Osigwe, I want to thank you very much indeed for joining us. He is, of course, the president of the Nigerian Bar Association, and he's also a senior advocate of Nigeria, and he was talking to me from our studios in Lagos.